Please rise. Justices of the Appellate Division, Supreme Court, First Department. Community here, your persons having business in the Appellate Division. One here, give your attendance and you shall be heard. Please proceed.
Good afternoon and welcome to the Appellate Division. I'm about to call the calendar. When you hear your case called, please identify yourself and then indicate for me how much time you'll require for argument today. The first case on the calendar is People v. J. Bradshaw. Okay, 8, 2, and 5. Matter of MS Children. I'm sorry, I didn't hear. Okay, we'll give you 5, 2, and 5. Hess, 938 Street, Nichols versus Cliffcrest Housing. 5, 2, and 5. Scopia Windmill versus Ocean Frome. Five, 2, and 5. People versus Vladimir Kroll. Say it again, I'm sorry. 6, 1. All right. 6, 1, and 6. Glaze Teriyaki versus MacArthur Properties. Do we have
Good afternoon, Your Honor. For the respondent, Kurt Sanitas, 5 minutes, please.
6, 2, and 5. People versus William Young. Submit. Denson versus Trump.
Good afternoon, Your Honor. David Bowles for the appellant, Jessica Denson. I'd like to have 8 and 2, please. Good afternoon, Judge. Jared Letty for the respondent, 6.
6, 2, and 6. People versus Carl Dandridge. Submit. Westport Insurance versus HBC US Holdings. Submit. Lopez versus Bendel. Submit. Brown versus Madisian. Submit. First case for argument on the calendar, People versus J. Bradshaw. Sure.
Good afternoon, Your Honors. As a preliminary matter, I didn't realize I was supposed to upload additional citations. I've given a copy to my adversary. Would the court take an additional citation?
We will. You can give them to the clerk.
Okay. Thank you. All right.
Make that the officer. Okay.
I'm going to start with the constitutional speedy trial issue. There were 11 and a half years passed between the indictment and the guilty plea. I think we can all agree this is an unprecedented delay. My adversary has not been able to cite a case with a similar delay. Many of the recent cases that have come down in the courts that have found constitutional speedy trial have found that a 6-year delay is too long. We should take a look, obviously, at the other factors that the courts consider in assessing. Let's start with the reason for the delay. The reason I submitted the additional case is because that's a recent case from this court, McDonald, where the court made clear that it's the DA's burden to show that there was good cause for a delay of this nature.
Well, counsel, doesn't it also need to be shown that he was prejudiced by the delay in some way? And how is that?
Well, prejudice is definitely one of the factors, Your Honor. Obviously, there are cases that say that even after a year that you could presume prejudice. This is 11 and a half years. It's hard to imagine that there wasn't prejudice, but if you look at the suppression hearing that was held 5 years after the indictment, 6 years actually after the indictment, you can see that the hearing judge commented about how little the detectives remembered about the procedures that led to the identification. She said, I realize how long it's been, but you don't seem to remember anything about what happened. And in fact,
How much time of this delay would you ascribe to the competency proceedings that went on?
well, Your Honor, on the competency, I said it in my brief, a press release from the mayor's office that said that people in New York system who have similar charges, if they have court-ordered competency hearings, they are on average in the system 3 times as long as the average person. Obviously, this is
But how much time was this defendant involved in competency proceedings?
from the on and off from the time of the indictment in July 2004 till the 2009 was the first period. So that's about, what, 5 years for the first part of the competency? I would argue that in that period, he had already pled guilty in the Brooklyn case. And despite these competency issues, the Queens case went to trial in 2010, yet this case continued on into 2016. Now, and if you look, obviously competency on its face would be an explanation for delay. But if you look at this particular case, you see an inordinate inefficiency. The judge recognized that the reports would get old, and then he would have to order a new competency hearing. This is a systematic
Counsel,
failure.
weren't there proceedings going on in 3 different counties at the same time? And how would the fact that there were conflicting mental health evaluations come into play, given what you're saying?
Well, one thing, there were proceedings going on in other places, but you can see as an example, when the suppression hearing is going on in this case in the spring of 2010, they held the trial in the spring of 2010 in Queens.
So is it your position that if there's competing mental health evaluations, they should be ignored by the court and the court should go forward?
Well, this judge, unfortunately, did not really take control of the situation. There are quotes in the record that I have in my brief where they say, let's kind of wait and see what happens in Queens. Maybe something is happening in Queens. There was a total passivity in this case in the Bronx.
But wasn't,
The people,
I'm sorry, go ahead.
the people were saying that?
The judge was saying that.
To what extent did the defense attorney accede to that, though? Had real questions about the competency of his client?
There was some consent by the defense lawyer. I cited in my brief Tigano, which is a habeas case in the federal courts, where they said that in a case where the defendant is repeatedly asking to go forward, and Mr. Bradshaw was resisting all these competency exams, that the courts also looked to the defense counsel to take some responsibility for moving the case along. And you can see that as this is proceeding, for example, competency raised its head again, I believe, in 2014. And the defendant did not want to be examined at that point. And the lawyer just basically said, fine. He acknowledged that there was a problem, that they send them to Mid-Hudson, they put them on some medicine, they bring them back. But he didn't then say, and then you have to move. So there was this continual repeating of that process of kind of getting the person competent or finding he's competent and letting the whole case then fall.
Some of it, let's look at it. Competency isn't a static thing, because I know you did make reference to the fact that there were trials going on in the other counties at times where he was at least determined to be competent in those proceedings, right?
Right.
But his situation changed over time. That's the nature of competency sometimes in some people, right?
Well, Your Honor, but in 2010, when they were having the trial in Queens, they were in the middle of a suppression hearing in the Bronx. It wasn't delayed for competency. They just put it over because he'd been convicted in Queens. I could see waiting a couple of weeks to see if he's going to plea bargain now that he's been convicted in Queens. But instead, the Bronx judge in June put it over to September. In September, the DA, even though they participated in setting the date, they couldn't do that date. It got adjourned again because they couldn't get a witness on that date. So I think it's too tempting to sort of blame all this on the need to assess competency.
Well, I
But
don't think it's blaming, it's just trying to figure out if there was a bona fide issue of competency, because there were times where defense counsel came in and said he's decompensating. There were times where he was excluded from the courtroom because the court, in front of his very eyes, saw that he was decompensating, even if he had been determined to be competent beforehand.
Right,
Isn't the-
I think
and the
there-
court's obliged at that time to make another competency determination, correct?
Right, yes, Your Honor, there was an instance in 2010 when that happened, but if you then look at the dates, they don't deal with it expeditiously. And that's the point I'm trying to make, that yes, you do need to examine the person, but the judge needs to say, okay, here's the deadline for the exam. These are court-appointed psychiatrists. I want to see it then. Here's the deadline for the next thing. You don't just shrug your shoulders and say, I have an obligation.
Counsel, so you also have a situation, don't you, that's compounded by the fact that the defendant was filing pro se motions even though he was represented by counsel?
Well, first of all, if the judge didn't think that was appropriate, rather than delay the case for months, the judge would say, I'm not going to take this.
I don't understand your position, because we are certainly exhorted to take mental health considerations into balance.
Right.
Much of what you're saying seems to indicate that the court should just ignore what's going on when you have a mentally ill an inmate, defendant in front of you.
I actually don't mean to leave that impression, Your Honor. What the point I tried to make is that systematically, you do need to address this, but you need to address it expeditiously. People who are our most vulnerable people in the criminal justice system, you don't put it on the back burner and let 4 years go by while you're trying to straighten out whether the person is
How many
competent.
mental health evaluations were made during the course of 12 years?
There were some in '05, there were some in '08, there was some in 2014.
Some meaning more than one per year?
Meaning done by different psychiatrists in the same time period. Can I just briefly say about the 30-30 issue?
You'll have time in rebuttal.
Okay. Thank you, Your Honor.
May it please the court, Daniel Young on behalf of the people. Your Honors, here the delay was caused primarily by two factors. One, the defendant's own mental health issues. For the first nearly 4 years of this prosecution, he was in and out of hospitals as they tried to figure out a way to ensure that he was competent to stand trial, and he was repeatedly found unfit. In addition, after he was convicted in Kings County and Queens County, defendant began the process of filing pro se motion after pro se motion. While it is his right to file those motions, particularly the speedy trial motions, they do naturally slow down the process of the trial. In addition, at multiple points, defendant did motion to have counsel relieved and be allowed to proceed pro se, and at one point he was even cautioned by the court, if you go down this course of action, it will slow your trial down. And yet defendant still insisted on having counsel relieved twice, eventually represented himself pro se, before allowing counsel to be reappointed for his plea.
And when you say counsel, there were in fact 3 different counsels during this time
Yes, there were
period?
3 attorneys throughout the entire prosecution.
And some of these adjournments were at the request of the attorney because they wanted to review the pro se motions. They also wanted to have their own evaluations by psychiatrists and things of that nature?
Yes, the bulk of the adjournments were because of the defense counsels wanting to be able to familiarize themselves with the file and get their own experts. In fact, there was a portion of delay from, I believe it was in 2013, from 2014 to 2015, wherein defendant simply refused to be evaluated by anyone other than a Dr. Goldsmith who had previously evaluated him, and he refused to be evaluated by a different doctor, and then he refused to be evaluated by Dr. Goldsmith unless his attorney was there. So this delay is not attributable in any way to the people. It's all entirely a result of his own mental health issues, his own litigious nature in filing multiple pro se motions, and his inability to work with his defense counsels. Even one counsel motioned himself to be removed
Well, let me just ask this question. All of that being said and considered, 12 years is still a long time for one case to be pending. At what point is it incumbent on the court to intervene and try to push it along? Was there any error there?
While 12 years is a long time, it can all be attributed to the defendant's own mental health problems and the necessity to ensure that he's actually competent to stand trial, and defendant's own motions filed after he was found competent again. Furthermore, defendant was in no way prejudiced by this delay. As defense counsel argued in the suppression hearings, they had the opportunity to cross-examine the detectives whose knowledge had wavered over the years, and they even sought to exploit that in their argument, saying that they were unreliable witnesses. Defendant cannot now argue that he can use that twice, both against the people and in his benefit, to show prejudice.
One question, was the defendant also serving a 50-year sentence imposed in Queens County?
So he was...
How does that factor into this?
He was serving I believe it was a 10-year sentence in Kings County that was eventually overturned. He was convicted in 2008.
But in Queens?
And in Queens, he was convicted in 2010 and serving his 50-year sentence. While pretrial incarceration is a factor for this court to look at, the simple fact of the matter is after 2010, while he was still incarcerated pretrial on this case, he was now incarcerated following a conviction on the other case. So that factor would weigh less heavily in favor of defendant. And unless your honors have any further questions, I would ask this court to affirm.
Thank you.
Thank you.
Rebuttal?
Briefly on the 3030 issue, I just wanted to point out that this court has held that the amendment to the 3030 statute saying you could appeal 3030 after a guilty plea should not go retroactive. Now, in this case, Mr. Bradshaw was told repeatedly by the judge that the issues that he had raised pre-trial would be raisable on appeal. So as I argued in my brief, if this, under the court's law, his plea is unknowing because he was promised that he could have the 3030 issue considered by this court on appeal. And I don't think it's good enough for this court to say, all right, we can't reach it, but we wouldn't have found it to have merit in any event, because when he pled guilty, he gave up his right to trial because he thought he had a legitimate chance to convince the court that his 3030 rights have been denied. Now that this court has held that this is not retroactive, that plea becomes unknowing, and as he has a right to have that plea vacated at this stage. I just also wanted to say that the DA brought out that he had made a request for reassignment of counsel. Well, that was after 7 years. So 7 years elapsed before he first sought to have a new lawyer. Similarly, he was sentenced to 50 years in Queens, but that happened after 6 years. So when you think about some of the factors that might have slowed the case down, the case has been going on longer than many cases where this court, the Court of Appeals, has found.
Counsel, did you indicate at the outset that the first 4 years were primarily spent in and out of psychiatric hospitals?
No, they were primarily in and out of psychiatric hospitals. He was in a psychiatric hospital briefly, and then what happened was the case would be adjourned for the court-appointed psychiatrist to examine him, but he was at Rikers. He was only briefly in psychiatric facilities. And as Mr. Bradshaw complained repeatedly, what would happen was the exams wouldn't get done and the case would be adjourned and he wouldn't be brought into court. So it's not accurate that he was in and out of psychiatric facilities for 4 years. Thank you.
Thank you. Thank you both. The next case is the matter of MS children. You may proceed.
Thank you, Your Honor. May it please the court, my name is Daniel Thompson with Davis, Polk, and Wardwell, and I represent the appellant mother, Yami S. Ms. S. suffered a mental health episode which required a 2-week period of hospitalization. That alone cannot constitute neglect of her children. The mental health episode was unforeseen and unforeseeable, and there is nothing in the record that shows any failure by the mother to exercise that minimum degree of care for her children, resulting in actual or imminent harm. ACS
Did
even...
the children arrive, did they have shoes on?
Your Honor, when there was an ACS supervisor that was present with the children for about 2 hours, at which point they had been in the hospital for many hours. They had been bathed by their mother, and the ACS supervisor testified that she did not know where the children's shoes were, that one of the children's shoes were.
Did the mother have shoes?
The mother did not have shoes. She had been admitted to the hospital the day before with a painful foot problem. Doctors had advised her that her shoes were an aggravating factor of that injury. And so I think that it's not surprising that the mother did not have shoes. Just to circle back quickly to Abigail, the oldest daughter's shoes, there was no evidence that she arrived at the hospital lacking shoes, and there's also no evidence in the record indicating any concern with the physical state of any of the children, including Abigail's and including her feet.
Did she tell the ACS worker that she had thrown away the shoes?
The ACS worker testified that on October 9th, when she was with the mother and the children, the mother told her that she had thrown away Abigail's shoes. However,
And how old was Abigail?
she was at the time, I believe, 9.
How does that factor into your analysis, counsel?
I don't believe that this court should credit that testimony from ACS for the truth of the location of Abigail's shoes. Rather, those statements were made while the mother was in the midst of a mental health episode. They are inherently unreliable statements. And there's nothing else in the record that supports that anything inappropriate was done with Abigail's shoes. I would also submit that there may have simply been some confusion in that moment regarding whose shoes were being discussed.
Counsel, in terms of the mother's acknowledgement of having a mental illness, is there any way that it could be considered that she lacked the insight to acknowledge that mental illness?
Your Honor, as the cases show, it's not simply a lack of insight, meaning if you have no reason to believe that you have a mental illness, your lack of insight into the mental illness does not satisfy the element of the neglect standard, asking whether you have failed to exercise a minimum degree of care for your children. Rather, what we look for is some evidence that the mother was supposed to be following a treatment plan, a medication regimen, leading up to that October 2016 mental health episode, and that she failed or refused to comply with that.
Well, that's not completely it, is it? I mean, is it the issue that they look to, or that we look to, is whether the mental illness interferes with the mother's ability, or here the parent's ability, to otherwise care for the children. So let me ask you about something else that was noted during this episode. I think we all agreed there was this episode where she was having a mental break. She was kept in the hospital for a fair amount of time. The children were in her care and custody. She brought them into the hospital with her, correct?
Correct.
Or they came to the hospital with her. It seems that somebody from the outside may have phoned in a report, and she was picked up from the street. But she reported that she had been living in a shelter and that she had some paranoid beliefs about the people in the shelter, and that she left without having otherwise made adequate provisions for the shelter of herself and the children. Would you say that that interfered with her ability to parent the children?
I would not, Your Honor. What the evidence shows is that the mother actually indicated, even in the midst of her mental health episode, her intent to go to the PATH office to seek, once again, an alternative shelter location for her family.
But then she refused help by the ACS worker to bring the children and to bring them to PATH to get alternate housing.
Your Honor, I would disagree with that characterization. While she at first expressed reluctance to go with the ACS caseworker, she eventually agreed and was willing to go with ACS to PATH, accepting their
Didn't she turn
assistance.
down ACS's, Afros's offer to help her to get to PATH on what was a cold and rainy night?
She at first refused and eventually agreed. And I think that refusal is understandable given the situation. She feared that her children, and reasonably so, feared that her children would be taken away, but she eventually did agree to go with the ACS worker to PATH.
Okay, you'll have some time in rebuttal. Let's hear from opposing counsel.
Thank you, Your Honor.
Thank you.
May it please the court, Jessica Miller for Respondent ACS. Your Honors, this court should affirm the family court's decision because a preponderance of the evidence proved, one, that the symptoms of the mother's mental illness directly impacted her 3 young daughters and placed them at imminent risk of harm.
Counsel, prior to the October 26th incident, had there been any proof presented that there was a treatment plan that the mother was supposed to be on, for her mental illness, that she was not following?
No, Your Honor, not immediately prior to her hospitalization in October of 2016. However, what we need to look at here is the mother's behavior and how it placed her children at imminent risk of harm. We find out after the mother was hospitalized that she was suffering from bipolar disorder and postpartum depression. And as a result, prior to her hospitalization, she was exhibiting symptoms of this mental illness, which caused her to have delusional ideations, erratic decisions to sleep outside the shelter, and paranoia and inability to provide appropriate hygiene for herself and her children. And it is because of these symptoms of her mental illness that created an imminent risk of harm for her children, in addition to the fact that her lack of insight into her mental illness also placed her children at imminent risk of harm, because before, during, and after her hospitalization, she failed to recognize that she could not care for her children. The appellant claims that the mother's psychotic episode was comparable to having a heart attack, but that ignores the evidence, which indicates that the mother was experiencing paranoid delusions, sleeping outside the shelter with 3 young children, including an infant, and failing to maintain proper hygiene for herself and her family prior to arriving at the hospital in October of 2016. Heart attacks don't cause people to have erratic, dangerous decisions made for children. They come on suddenly, and they don't show signs of mental incapacity days prior to coming on. This case can't be looked at in a vacuum just because after her first trip to the hospital, the mother was seen as devoted to her children. ACS is not denying that she is a loving, devoted mother, but in and around the time of her hospitalization, she was exhibiting behavior that placed her children at imminent risk of harm.
So you discount, you believe that we should discount your adversary's argument that this is essentially but a single incident that should not lead to neglect finding, am I right?
Yes, Your Honor, because the symptoms prior to the mother's hospitalization indicated that she had poor decision-making ability, she had poor insight into her capacity to parent her children, and she was experiencing delusional ideations and making dangerous decisions for her children that placed her children at imminent risk of harm. And the bench has no other questions. This court should affirm the family court's decision.
Thank you. Rebuttal?
ACS concedes that there was no treatment plan that the mother failed to follow. There is no other theory to satisfy.
Well, it doesn't sound like she was she given a treatment plan?
There's none apparent in the record. There's simply no evidence in the record indicating that a treatment plan even existed that the mother could have followed that could have prevented or mitigated the mental health episode that occurred in October 2016. And there's no other theory.
So your position is that without a prior treatment plan, any psychotic break shouldn't result in neglect? regardless of how that impacts the children?
Your Honor, in this case, I think that's the only theory available to ACS. But what we're really talking about is that first element of the neglect standard, which requires some failure by the parent to exercise a minimum degree of care, and it asks whether they have done so under the circumstances then in their existing. The neglect standard does not punish mothers for events outside of their control. Here, there's no evidence that she had any control over what would happen in October 2016.
So we
Well,
know that she-
isn't, I question the use of the word punishment. The finding of neglect is to protect the children and not necessarily to punish the mother. It's a statement, I guess, not a question.
Understood, Your
Yeah.
Honor. I was thinking more so of the stigma associated and with the neglect finding and the fact that it follows a mother around it.
There's no, there was a, you're not challenging the disposition, are you?
We are not, Your Honor. I believe that the disposition has been mooted by subsequent proceedings in the family court.
Yeah, there was a termination of parental rights proceeding that was initiated at some point after this, after this appeal, I believe, was perfected, or maybe not.
That may be so. My representation is confined to this appeal, and I don't have
Fair
visibility.
enough. I ask no more then. All right. Any further questions, counselors? Colleagues, counselors, thank you both. Sir, I understand you're doing this pro bono through your law firm, and I want to thank you for your pro bono work, and please convey our thanks to your law firm as well for
will.
allowing you us the privilege of having you here.
Thank you very much.
Hess 938 versus Cliffcrest Housing. You may proceed.
May it please the court, Michael Capilupo of Chris and Forrestine for the appellants. Champerty may be an affirmative defense, but it is not a private cause of action. That's from this court's Cooper's decision, 52 AD 2D 493. The most a respondent could ever hope to achieve out of this case is merely dismissal of the case. The respondent can never get a judgment for Champerty because there's no such thing. It's an affirmative defense, that's all it is. So respondent's third-party claim and counterclaim for Champerty, those both should have been dismissed right off the bat. In any event, it wasn't Maverick that bought the judgment, it was Hess 938. They may be affiliates, but there's nothing in the record to suggest that they're alter egos of each other. And along those lines, that's a piercing the corporate veil theory. And in order to allege that, you need to allege complete domination, and that is used to commit a fraud. None of that was alleged here. Now, turning to the affirmative defense of Champerty, there is only one thing that the Champerty statute prohibits, and that is buying something for the purpose of commencing a lawsuit. That is the only scenario where the statute applies, and it is a narrowly construed statute at that. Where the purpose of the transaction is to commence a lawsuit. Hess 938 bought a final entered money judgment. And what did Hess 938 do with the judgment? It issued a property execution to collect on the judgment. There was no new lawsuit, no new pleadings. It was a property execution in the existing case to enforce the lien of the judgment. And a property execution is not a lawsuit. So right there, it does not fall within the confines of the statute. Now, the Second Department dealt with this very question in Concord Landscapers. That's 41 AD 2D 759. The court held that buying a money judgment for the purpose of collecting on it, and I'll quote, the statute, quote, does not prohibit such a purchase for the purpose of enforcing the judgment's collection or pursuing its lien, as, for example, by execution, end quote. That's exactly what we have here, Your Honors. The Second Department actually expressed some reluctance in reaching that conclusion, because it meant that assignees of judgment creditors could go and enforce judgments to sell the debtor's property when they had no relationship to the original judgment creditor.
Counsel, is there any reason why we should say, well, maybe discovery needs to be held in order to decide this factual issue of Champerty? Isn't that an inquiry that should go to the jury once there's been discovery?
Well, it's not a question of fact when, as for the counterclaim and third-party claim, because there is no private cause of action. So in terms of Your Honor's question for the Champerty defense, the Second Department has already dealt with this issue and said essentially a bright line rule that when you have a judgment that's purchased for the purpose of enforcing it to sell a debtor's property or to collect on the judgment, that is not Champerty. So there was no question of fact to go to a jury or to go to the judge as a trier of fact.
So counsel, I want to address the elephant in the room, which is your client seeks to collect money based on invoices naming a different person, a different entity, right? So Hess is suing Cliffcrest, but Del Mar Management is named on the invoices. Wouldn't you like a chance to do discovery?
Well, on that point,
Might
Your
it
Honor,
not be helpful to you?
on that point, Your Honor, we established the account stated cause of action because payments were made on the account. So the case law is clear
How
that
did you establish that payments were made on it?
that was
What
through
is the evidence that payments were made on it?
that is through the account histories and invoices that were introduced by the affidavit from the representative from Hess Corp. So those.
Are you referring to page 53 of the record? No, not 53, yeah.
53. 53 is one of the invoices.
And you have other bills, and then before that, there's a list of items. One on that list showed that payments had been made.
This shows payments were made on looking at page 40 of the record. This is the last 5 or 6 items all reference payment on account, payment on account, payment on account. So these were all payments that were made either by Cliffcrest or on behalf of Cliffcrest. So these acknowledge that there was an account due, and that and then the balance due, according to case law, is that is an account stated cause of action. If there are no further questions, Your Honors, I'll reserve for rebuttal.
Thank you.
Good afternoon, Your Honor. Yetta Curlin from the Curlin Group on behalf of the respondent, defendant Cliffcrest.
Can we start with the point that your adversary made that you can't sue Maverick because you can't get an affirmative judgment based on Champerty?
Right. Well, so both of those statements are incorrect. First of all, the appellants claim that the defense of Champerty can only be used when there is something bought for the purpose of commencing a lawsuit. But Judiciary Law 489 prohibits any person or entity directly or indirectly from soliciting, buying, or taking an assignment.
But who bought the judgment? Was it Maverick or was it plaintiff Hess 938?
Well, so to the point of the corporate veil, piercing the corporate veil is completely irrelevant here. Corporate veil is only pierced or
Who's
considered.
talking about corporate veil? Which entity actually bought the judgment?
It is a good question of fact, Your Honor, which is why the trial court has not thrown out the idea of either ruling in favor or against finding of Champerty, but that there is just simply more discovery that needs to be had before a decision can be made. And to the point of 489.
What evidence is there that it's Maverick that bought the judgment?
Maverick is the entity, and why it was cross-claimed is because the plaintiff has admitted that the plaintiff, which is a single-purpose entity, was formed by Maverick and is controlled exclusively and completely by Maverick, which is all that's required by appellant's own case law. The case law they cite claiming that the corporate veil needs to be pierced is clearly distinguishable. Corporate veils are
Still,
pierced.
Why isn't the claim against Hess 938?
What is the claim against
Why
938?
isn't the claim against Hess 938? Whatever the relationship may be with Maverick, it's Hess 938. It sounds like from what you're saying that it's Hess 938 that brought the judgment.
Yes, well, there's an affirmative, first of all, there's no cross-claim seeking damages, and that entire argument is not before this court because it was never raised until appellant's brief in reply in this appeal. It was never raised in the underlying summary judgment motion. It was never raised in their answer to the cross-claim, and it's simply not before the court. But the respondents are not seeking any damages of claims against Maverick or 938 Hess. The reason that they're cross-claiming Maverick is because Maverick is the actor involved in this process. So there's a claim of champerty both as to 938 Hess and as to Maverick.
So if it turned out that Maverick did not own the claim, then there would be no claim for champerty against Maverick? Are you considering
In this
that?
action, there would be no claim potentially against Maverick. It's very hard to predict. This is why the trial court...
Well, I said if.
Yeah,
I said
yes,
if.
yes,
Turns out they don't own it.
Or turns out, there's a dispute of facts here, and this is why the lower court's decision has to be affirmed, because all they're saying is that it's premature to make a decision as to whether champerty exists or doesn't exist. At this juncture, there hadn't been any depositions, and the documentation with regards to the underlying claims were simply inadmissible. The affidavits were inadmissible. The high burden that appellants are asking the court to overturn the trial court's finding, they've simply not met. They have not showed that the trial court committed clear error or that the findings were beyond the exercise of any reasonable discretion. And they've also failed to meet their summary judgment burden to show that there's an absence of material issues of fact. And as Your Honors had intimated earlier in some of your questions, instead, appellants ignore the fact that the invoices that form the basis of their claims were sent to the wrong address, addressed to the wrong entity, are not authenticated by anyone with firsthand knowledge. Also, contrary to appellants' claims, parties dispute whether the fuel was ever ordered or delivered. Many of the delivery receipts are missing signatures, and a prior payment for prior purchases of fuel deliveries neither obligate respondent to pay monies.
As to the summary judgment and account stated, so why hasn't plaintiff made out their case by virtue of the fact that Dijon in the motion for a default judgment states that, it's on page 39 of the record, that payments were made on account and there remains an amount due and owing to plaintiff in the sum of $48,000 plus. And then in support of this motion, Jason Leibowitz submits an affidavit in which he says, page 21, that various payments were made by defendants to Hess and that the balance of $48,276 remains outstanding. And he knows these facts to be true based on the statement of account and copies of the outstanding invoices annexed to the Dijon affidavit. And then, of course, there is this statement of account, which your adversary pointed to before. So why doesn't that make out the statement of account?
Thank you, Your Honor. As the trial court found, those affidavits are inadmissible because Mr. Leibowitz has no firsthand knowledge and doesn't even attest to...
He says it's based on business records, and aren't these legitimate business records?
No, as the trial court found, these were the business records. The gentleman, Joseph, the other affiant, was actually from Hess Corporation, and Mr. Leibowitz makes no reference to having any knowledge as to Hess's business decisions and no firsthand knowledge. Also, there's a dispute of fact. Mr. Leibowitz asserts these things, but then you have the affidavits and statements both in the pleadings as well as the affidavits of Ms. Dea Thomas, as well as the evidence itself, where there's, for example, signatures missing in the deliveries of the fuel. There's a bona fide dispute over whether or not the fuel was even delivered, and there's a question about whether or not these are all on the same account, as they are sent to Del Mar and addressed and mailed to a different location altogether. So it raises very serious questions and concerns, and as the lower court pointed out, in order to make an account-stated claim, you have to show that the account has been mailed to the party that you're seeking the debt from, and that there's been a sufficient time in which they have not objected. But as you can expressly see in these documents, they were not mailed to the respondent here. They were mailed to a different party altogether. That being said, all we're saying, yeah,
Your argument.
yeah, the last point I want to make is,
No, not a new point. You need to wrap it up. You're over your time.
okay,
We have your briefs, honestly.
Okay.
You know, we're aware of the arguments
right.
and the record on appeal.
I appreciate it. I just, the argument about cross-claims was never raised or preserved, and we are not seeking damages. And it's not just the point of initiating an action, it's proceeding thereon, which is clearly happening here.
Thank you.
Thank you, Your Honor.
All right, let's hear from your adversary in rebuttal.
Your Honors, there is no question of fact as to who
Did you raise the issue about whether you could bring a private right of action under Champerty in the court below, or is this just raised on appeal for the first time?
Your Honor, we did not raise that exact issue below, but it is a pure question of law. It is appearing on the face of the record, and it cannot be avoided if it was brought to the attention of the trial court. So I understand that it may not have been raised exactly below, but it is a pure question of law. They simply cannot have a judgment for Champerty. There would be no such thing. There is no question of fact as to who the judgment was assigned to. Page 59 of the record is the assignment of judgment. It says it was assigned to Hess 938 St. Nicholas Judgment LLC, which is the plaintiff appellant. So the judgment was never assigned to Maverick Real Estate Partners, who's the third-party defendant and appellant. The burden here is not a high burden of clear error. It is a de novo appeal. One last thing I'd just point out is that...
As to account stated, how do you get past the fact is noted by your adversary when you start looking at the invoices, just to look at one of them, it's billed to Del Mar Management, shipped to Cliff Crest, customer name Del Mar Management. Is that the sort of invoice that can give rise to summary judgment for account stated?
Yes, Your Honor. If you do look at the invoices, they say Del Mar Management, followed by Cliff Crest HDFC, which is the defendant here, the respondent. These invoices did have delivery of fuel oil to Cliff Crest HDFC, and payments were made on the account, at least 6 payments amounting to about $40,000.
But then it says customer name Del Mar Management. I mean, you're asking us, bear in mind you're talking about summary judgment and account stated, you're asking us to make Del Mar Management the same entity as Cliff Crest. Isn't that what you're asking us to do? To regard them as one and the same? And what would be our basis for doing that on this motion?
Well, these are deliveries of heating oil to Cliff Crest at the property, the subject property. We're not talking about deliveries of heating oil to Del Mar Management at its management location, which may not be at the property. We're talking about directly to Cliff Crest HDFC.
We're not talking about the deliveries now. We're talking about the bills and the invoices. And the bill is to Del Mar Management, and you're seeking summary judgment against Cliff Crest.
Well, yes, in this case, Del Mar Management is based on the invoices. What is happening here?
I understand it's your point that they are one and the same, but that's not what the invoice says when you look at it.
Well, the invoices are not so much the determinative factor here. It's that there were payments made for these deliveries by or on behalf of Cliffcrest HDFC. So when those payments were made, the case law says you either have to show that payments were made or that invoices were properly mailed. Here, we're talking about payments were made. So the account stated is established by the payments themselves being made. We don't need to show, respectfully, we don't need to show that the invoices were named properly or mailed properly. It's based on the payments that were undisputably made. There was never an issue raised in opposition to that point.
Thank you.
Thank you, Your Honors.
Both. Scopio Windmill against Ocean from, please step up. You may proceed.
Good afternoon, Peter Sartorius for defendant respondent. This court should reverse the lower court and grant appellant's summary judgment motion because plaintiff's theories of proximate causation and damages are.
So Robert Albergati, who represented Scopio in bankruptcy court, says that your client's failure to file the UCC-1 on time costed its position in bankruptcy court as a secured creditor for many months. And that as a result of that, and that had you not cost them their first in line position, they would have been in a position to collect the debt without having to worry about other claims.
Sure.
But since they couldn't because of Rule 547, they had to deal with all of the other creditors, with the farmers who also had claims, and they lost their whole negotiating position as a result of that lateness in time filing.
And that's the whole premise of the plaintiff's claim for proximate causation and damages in this case. What it doesn't account for is the fact that the farmers were owed $21 million. They weren't going away. They had very aggressive litigation counsel. They had claims regardless of when.
When did their claims ripen, though? I mean, at some point, they could only go into bankruptcy. They forced WTG into bankruptcy, right? An involuntary bankruptcy petition was filed by them, by the growers, right?
Correct. That's correct.
All right. They could only do that once their claims ripen, once they were owed money, right?
That's right.
So where does that fit in? I just didn't understand it from the record in terms of the timeline, such that if, in fact, the UCC perfection statement had been timely filed, the safe harbor would have been not a factor. In other words, you know, you're saying we don't know what the growers would have done. They would have been aggressive anyway. But they couldn't be aggressive until they actually had claims.
Well,
right?
They certainly had claims against WTG as soon
as of when?
As soon as they delivered their guar crop.
Again, I'm looking for a date.
It was.
So, I'll be more
you know, I'm not entirely certain that that's in the record. I believe it's.
And I'm thinking to myself, if their claims didn't ripen, you know, it was sort of this amorphous between 2013 and 2014. But if they didn't ripen until after the safe harbor would have passed had the UCC been properly filed, well, then the damages don't really look all that speculative, do they?
No, they are speculative because regardless of when the UCC-1 was filed, they still had claims for equitable subordination. The plaintiff's theory.
Does that really matter? Because, you know, I'm not saying that this is so, but according to Scopio's expert, Anthony Ancampora, he says that at the UCC-1 been filed on time, Scopio was a fully secured creditor, and they would have collected their debt entirely if there was an $8 to $9 million liquidation. And they wouldn't have to deal with the farmers at all. They would have been first in line, and they would have just had their debt paid.
Sure, and we discussed this very issue in our briefing. Regardless of when the involuntary bankruptcy happened, or even if the plaintiff sought to foreclose, its claims, even if it was a fully secured claim at the time of the involuntary bankruptcy or at the time of the foreclosure, its claims would still be subject to equitable subordination in a bankruptcy. And plaintiff's theory is that the growers or the farmers never would have sought equitable subordination or never would have sued Scopia in the Texas state court cases for various fraud and veil-piercing claims for which Scopia, the plaintiff here, paid $6 million.
Scopia is a fully secured creditor, and their UCC-1 is filed on time. Why don't they collect, regardless of what, and I know the farmer's claim is very sympathetic, but why don't they collect, regardless of that?
Because look at what actually happened. When they did seek to collect, when they did threaten to foreclose, the farmers put them into involuntary bankruptcy and said, bankruptcy court, hold up, they can't foreclose. They perpetrated a massive $21 million fraud as controllers of the company. And they're not, bankruptcy court is a court of equity. Inequitable subordination, which the plaintiff's expert concedes is something that the growers, a claim that the growers would have had regardless of when the UCC-1 was filed. If it was filed shortly after the December 2012 closing of the original loan, or if it was filed in 2013 when it was actually filed. And for that reason, the fact that the Scopia could have been a secured creditor at the time that the farmers put them into involuntary bankruptcy in middle of 2014, it's irrelevant and does not obviate the growers' claims of equitable subordination. It had those claims, had those defenses, and certainly would have asserted them in any event, regardless of when the plaintiff's UCC-1 was filed. I see I have a red light. If
You'll have some time on rebuttal.
Thank you.
Let's hear from your adversary.
May it please the court, Thomas Moore for the Scopia entities. To begin with your question, Your Honor, about the timeline, the loan was made at the end of 2012. A competent lawyer would immediately have filed a UCC-1, putting the world on notice of the existence of the loan. Under 547C of the Bankruptcy Code, that creates a safe harbor where there is no longer any chance of a preference action, period, end of story. That's the law. We've stated that law. It's never been refuted. They hired a former U.S. bankruptcy judge as their expert. He's never challenged it. That's the law. There could have been no preference action.
As this proceeding goes on in bankruptcy court, you end up putting in a lot of new money in order to, because the charges are that there's some sort of fraud involved in what transpired, which doesn't that give that a certain credence when you consider that you're the one who's holding this unpaid debt and you're putting in a lot more money and giving up a lot of your rights?
Your Honor, it's the uncontested testimony of the people who wrote the checks and the lawyer who told them to write the checks is we only did it because we were in Texas with a gun to our head, a gun they loaded and handed to the growers. The essence of the growers' claim was we intentionally cheated them by intentionally hiding the lien.
You intentionally didn't file it so that they would come forward and make all of these further, grow the crop and sell it, and this is all part of a scheme to defraud them.
None of which could have happened, Your Honor, if there had been a public filing disclosing the lien. That is the keystone that their entire growers' case is based on. We're not just saying that. If you read the pleadings, that's true. If you listen to the deposition of the growers' main attorney, the way we read it, he admits it. They disagree with that. That's a factual issue for trial. They had no claim that bothered us. We've never said they might not have come forward with a claim, but the lawyer who defended us in Texas said the only reason you guys have to settle, the only reason you should cave is their negligence. He said he wouldn't have feared any of those claims. There couldn't have been a meaningful claim for equitable subordination because there would have been no fraud. You can't hold against us what we did because of their negligence and say that that tells you what we would have done in the alternative universe where we were a fully secured creditor, what the law calls the 800-pound gorilla, entitled to the absolute priority rule of bankruptcy. First money out, period, end of story. It would have gone one of two ways. Fully secured creditor, you go into a meeting, you say, guys, let's work it out. We'll give you something, and there would have been a handle. Everybody in this world says that's what would have happened. In a worst case scenario, it doesn't happen, we liquidate. In order to put a simple case before the jury, we're simply looking for liquidation damages.
Right, you indicated to the court below that you were only seeking worst-case scenario. So, and I just want to make sure I understand that. So your worst-case scenario is that you would be able to recoup your loan as a priority. That's it?
So we would have gotten our $6 million in interest back. We would have avoided paying another $6 million to settle, and there are $2.5 million in legal fees in Texas, another $2 million in legal fees fighting with our D&O carrier for coverage. And that's just Windmill. The managers of the entity, there's to be decided later whether they're in this case or they're out, had to put in another $12 million to get out of the fraud claims and to settle the matter.
So that's your worst-case scenario, $25 million in damages?
Worst case scenario is we would have been $6 million up, avoided $12 million down for Windmill, plus the holdings manager's own damages, which are a separate issue. Because we would have liquidated, there was enough money to pay us off, we go home. We take our ball and we go home. We don't sit there for years being beat, or months being pummeled in Texas state court into the bankruptcy court, having to resist motions for trustees and all kinds of things that were premised on the failure to give public notice of the existence of the lien, a failure of theirs. We're simply seeking a trial, Your Honor. If they want to beat us up and try and say, you guys love this company too much to walk away, you never would have done it, do it. Cross-examine my witnesses. But you don't get summary judgment on that basis. Your Honor, at oral argument, they relied on a case, and I just point the court to it because it's new, it's not in the briefs, I don't know that it's fair grounds for argument now. But they raised it in oral argument. This was decided by the same judge. And that is the All-Rose Steinway case, was decided by this court 3 weeks ago. In that case, the judge granted summary judgment based on the Phillips specialty case. They argued that their case was like that, and the judge said, no, it's not. That case is speculative. This one isn't. You've got the UCC one in the bankruptcy law. Well, this court recently reversed that, even the more, a much more speculative case, and sent the case back, reversed her grant of summary judgment. Lights on unless you have any further questions, Your Honor.
No, thank you. Let's hear from your adversary on rebuttal.
Just very briefly, setting aside the $6 million, I guess, liquidation value, which is the first item of damages that Mr. Moore referenced, he also referenced the $6 million that they were, he says, required to pay the growers in the Texas state court litigation, which he claims or asserts was only brought because of a delay in filing Windmill's UCC1. We reference this a lot in our briefing. Those voluminous complaints filed by 400 growers, it references, he says it's the keystone to their complaint. It's referenced one time in those complaints. The true cause of those complaints was the allegations that Scopia and Windmill perpetrated a massive fraud on these growers. And just looking at the complaints, it's pretty, I think it's fair to say that those complaints had nothing to do with Windmill's UCC1.
We could determine that as a matter of law now?
No, I think what you can't determine, though, Your Honor, is that whether or not the growers would have filed those claims, regardless, if Windmill's UCC1 was filed earlier, whether they would have, when they would have, what claims they would have asserted, would they have asserted different claims, is something that is entirely speculative. And the amount, as a matter of law, those sorts of that sort of conjecture is insufficient as a matter of law. We cite to the Phillips case to sustain a cause of action for legal malpractice.
You're talking about damages.
I'm sorry?
You're talking about damages?
Damages, yes.
Did you have an expert that said that?
We we don't have, it's not, we didn't submit it in opposition, in support of the summary judgment motion.
They did, right? They had an expert who made an evaluation as to what their damages were, who offered an expert opinion.
They offered an expert that opined that, just in summary, if the windmills UCC1 was filed earlier, the growers would have done this, Scopia would have done that, the bankruptcy
But
court
you
would have
didn't-
ruled this way.
You didn't offer expert rebuttal, right?
That's correct.
Thank you.
All right, thank you. Thank
Thank
you
you.
both. People versus Vladimir Kroll. Step up, please. You can proceed.
Good afternoon, Your Honors, and may it please the Court, Alexandra Mitter on behalf of Appellant Vladimir Kroll. Imposition of points under Factor 12 for acceptance of responsibility raise constitutional concerns when the defendant has a direct appeal pending, and particularly whereas here the defendant testified at his trial. This Court has not addressed this issue before, but it should join the Second and Fourth Departments, both of whom have held that the Fifth Amendment makes points under Factor 12 problematic, or at least provides the basis for a downward departure. Now, the Second Department has held that points under precisely these circumstances are not appropriate. They explained in Britain that this unique situation presents a defendant with either the choice of exercising their Fifth Amendment privilege against self-incrimination and appealing with the hope of dismissal or success on a retrial, but being assessed points, or not getting the points, accepting responsibility, and possibly incriminating yourself and ruining any chance.
So how do you reconcile the Second Department's position with the Supreme Court case of McCune versus Lyle?
So McCune versus Lyle, I think, supports our position, Your Honor. McCune versus Lyle, looking at O'Connor's concurrence, which is the controlling decision, because it was a plurality decision, and Justice O'Connor's concurrence is the narrowest ruling. She noted specifically that the loss of good time, which is what Mr. Kroll faced here, would surely implicate the liberty interests that the Fifth Amendment is designed to protect. Now, we have an additional liberty interest here, which is that Mr. Kroll receive a correct risk assessment. That is a separate liberty interest that the Court of Appeals has recognized as protected. So we have two interests here that the Fifth Amendment protects, and Mr. Kroll being forced to admit responsibility while he has an unperfected direct appeal is incompatible with his Fifth Amendment rights. And that is why the Second and Fourth Departments, when presented with this issue, found that Factor 12 could not be a basis for determining the registrant's risk level, whether that's as a downward departure or the points themselves being inappropriate. So as I mentioned in Britain, the Second Department held that points were not appropriate. In Fuse, the prosecution actually conceded that points were not appropriate under these circumstances. And then in the Fourth Department, we have a downward departure assessment being made instead, where the court in Kearns explains that quite clearly the risk assessment guidelines do not contain exceptions with respect to a defendant's reason for refusing to participate in treatment. And so because those reasons aren't considered by the risk assessment instrument, they provide a basis for a downward departure, and the court recognized that. Now, this is a question of first impression for this court, and Respondent has provided no reasons for this court not to follow the Second and Fourth Department's decision. The only argument that Respondent has made against the thoughtful reasoning of these other departments is outside the record, and it's outside the record because it wasn't made below. This argument regarding these purported guidelines was not made below, so it's both outside the record and unpreserved. It's also, for what it's worth, without merit. There's absolutely no basis, even assuming these guidelines are the guidelines, to decide that DOCS has absolutely any basis to require a Bronx district attorney from prosecuting a case against Mr. Kroll based on what he said during sex offender treatment program. Respondent has offered no basis that DOCS, has a state agency, has any ability to bind a city prosecuting office in that way.
So, counsel, your position is that sex offender treatment programs cannot require inmates to acknowledge responsibility for a sex offense because that is compelled self-incrimination?
Oh, that's very much not my position at all,
Or
Your
are
Honor.
are you saying that that applies only if there's an appeal?
That applies in a very, very limited subset of cases where people went to trial and have received relatively short sentences so that they still have a as yet unperfected direct appeal. And the fact that this has only come up in a few cases, I think, speaks to the limited scope of the potential impact that a
So we
decision
can
would
envision,
have.
is it possible to envision a scenario where no one in a sex offender treatment program would acknowledge responsibility because they were all filing appeals?
No, so it's not about the filing of an appeal, it's the status of that appeal. And sex offender treatment programs happen very close to the end of a sentence. And so a sentence has to be really, really short for that appeal to be unperfected at the time a person is going through sex offender treatment. And if we look at the sentences that the defendants in the 4th and 2nd Department decisions had, we're talking about a 16-month to 4-year sentence, a misdemeanor sentence, a 2-year sentence, and Mr. Kroll here had a 3-year sentence. So we're talking about really short sentences for defendants that went to trial. So I think that the group of people we're talking about having Fifth Amendment rights being implicated by the sex offender treatment program's requirement to admit guilt is vanishingly small. And so I don't think there needs to be any concern about the impact that this would have on the sex offender treatment program going forward. And so if there are no further questions that Your Honor has, I will reserve my remaining time for rebuttal.
Thank you. You can proceed.
Good afternoon, and may it please the court, John Commendoria for the office of the Honorable Darcel D. Clark. Your Honors, the Sora court here correctly found that 10 points was properly assessed under Factor 12 and properly exercised its discretion in denying a downward departure, and this court should affirm. Initially, it's undisputed and it's proven by clear and convincing evidence that defendant refused to accept responsibility for the crimes he committed and that he was removed from the sex offender program. In fact, he goes so far as to write to the Board of Sex Examiners, "I cannot in good conscience accept responsibility, admit guilt for crimes I did not commit. I was never, nor am I, a pedophile or a child molester. I tried explaining this to my senior offender rehabilitation coordinator, but she did not want to even hear it."
With the record, but I guess really the question really is for you is the legal aspect of this, which is the Fifth Amendment. Does the RAI Factor 12 account for the reason that somebody may decide to not accept responsibility?
Your Honors, there's case law that says it doesn't, but our position is that it does account for it, and that's because
How would this distinguish between somebody who had an active appeal pending in which they wanted to maintain a Fifth Amendment right and somebody who doesn't? Does the RAI account for that?
So there's a twofold response to that. Initially, and as I said in my brief, the reason why there isn't a downward departure assessment, for instance, like there is with the statutory nature of the crime, is because acceptance of responsibility is so fundamental to the rehabilitation of the defendant, of the sex offender, so as to keep from recidivism. As the Supreme Court said in McCune v. Lyle, 80% of people that have not been treated or have refused rehabilitation are likely to recidivate.
Well,
And the
Counselor,
purpose...
can I just ask this question just on that note? Is there ever a situation where someone who goes to trial, maintains their innocence, and continues to maintain their innocence, wouldn't be negatively impacted by Factor 12 if they continue to maintain their innocence?
There could be an instance, Your Honor, and as I raised in our brief, as cited by the Northern District of New York in their case, where it found that the guidelines at the time he entered the program offered him immunity, so that anything he said, any acceptance of responsibility he said during the program couldn't be used.
Counsel, what guarantee is there that immunity will be effective and that any court or anyone else will be bound by it?
I'm sorry, Your Honor, what did you ask?
What guarantee is there that supposed immunity that the defendant is offered will be binding on a court?
he could raise reasonable reliance upon bringing it before the court if it was ever used against him.
Has that ever been done?
There has never been one instance in this state, as far as I'm aware, of the people or a prosecutor having tried to use statements from a sex offender treatment program against the defendant.
But they could. There's nothing prohibiting them.
No, but with regards to the program guidelines and the agreement that he made.
I know you keep referring to the program guidelines, but the prosecutors aren't a party to those guidelines, and they're not bound by them in the true legal sense. Isn't that true?
I mean, it wouldn't be any different than if there was a crime that occurred both in Westchester County and Bronx County. If Westchester gave immunity to that defendant, the Bronx County would not necessarily be a part of that, but they would still be bound by that immunity as well. And the only reason why I brought up those guidelines is not so much as a give-all, end-all, but because the dynamic, as is raised with regards to the Fifth Amendment, is misleading without that key fact. It's not just a matter of, oh, his appeal was pending. There was also that key fact and that agreement or that guideline that he was part and privy to when he entered the program. In fact, it puts into context all of the things he says in his April 2019 letter. And it also goes to show as to why the Board of Law Examiners said it was not true when he said he wouldn't have to accept responsibility upon entering the program. The Board of Law Examiners says that in the case summary because of this agreement. So, and unless your honors have any further questions, the people do ask for an affirmance.
I'm just curious. So what you're saying is that at the appeal of, theoretically, at the appeal of this defendant, the people would not say, of course he can't maintain his innocence because did you know that he acknowledged responsibility during his sex offender treatment program? Is that what essentially you're saying?
Yes.
And you wouldn't use his statements against him at a possible retrial if there was a reversal of the conviction?
That's the clear agreement between the state, the government, DOCCS as authorized by Governor Cuomo at the time. It's the clear agreement between the government and the defendant in the program. It wouldn't be used against him. It couldn't be used against him. And to the extent that if, let's just say, his appeal was vacated, I would think that any subsequent things that happen, like his sentence and what occurred during his sentence, would also be sealed. And I see that my time is up, and the people do ask for an affirmance.
Thank you.
Counsel, what's your response to your adversary's argument about this grant of immunity?
While I appreciate respondents' benevolent promise that the district attorney's office would not use this information, the fact of the matter is there is absolutely nothing binding them to that position. And the trial court, or the SORA court rather, explicitly acknowledged that and said it was in the absolute discretion, quote unquote, of the trial court to decide whether or not to allow this. And so the Fifth Amendment doesn't require us to demonstrate that under 100%, with 100% certainty that potential criminal liability would result. There just has to be a serious concern.
Why wouldn't, this is obviously a representation made by a state actor. Why wouldn't the state prosecutor be bound by that representation?
This is a representation made by a state agency that has absolutely no authority over a city prosecuting office. That there's just absolutely no connection between one and the other that would bind the district attorney's office. And I think it's
But they're extracting this admission from the defendant, presumably against his will, under an agreement not to use it against him.
And that is why it is a compelled Fifth Amendment issue, Your Honor. I appreciate the promise that the DA will not use it, but absolutely nothing prevents them. Not this piece of paper, which I just want us to not lose the forest for the trees, is not in the record before this court. All this argument we're having is about something outside the record and that the prosecution did not raise below because it has no merit. Don't you think the trial court prosecutor would have raised this argument if she thought it had any merit whatsoever? The trial prosecutor, who's the one making precisely these types of discretionary decisions that respondent is arguing now? It has no merit, and that's why the Second and the Fourth Departments didn't deem it worth consideration or mention any either. And just to answer the first question that was put to respondent when he stood up here, the RAI absolutely does not take into consideration the reasons that a person refuses to admit guilt, and that is something respondent acknowledged in his brief at page 26 when he said, defendant is correct in stating that the guidelines do not contain exceptions for a defendant's reason for refusing to participate in treatment. Thank you, Your Honors.
Thank you. Thank you both. Glazed teriyaki versus MacArthur Properties. You may proceed.
Good afternoon, Your Honors. May it please the Court. Bradley Polina for the Appellant Glazed Teriyaki, LLC. Your Honors, the Supreme Court read the lease here in an incorrect, strained, and inequitable manner that granted this landlord a windfall monetary award that contravened the clear and unambiguous terms of this lease. Glaze's total monthly rent obligation for the period at issue was $368,000. During that period, in good faith and with the implicit, if not the explicit, blessing of the trial court, Glaze remained in the premises and continued paying monthly rent to the landlord, which was accepted by the landlord in lieu of pursuing an eviction in civil court for an extended period of time. However, later, in awarding holdover rent, the Supreme Court stretched and strained to make Article 59B applicable here and has now told Glaze that for that time period, it owes another $600,000 in addition to monthly rent already paid, of which there are no arrears. So Glaze has been ordered to pay over $968,000 for a time period where really its rent obligation was $368,000, i.e. nearly 3 times its true rent obligation. This kind of inequitable result was only made possible.
As of what date did Supreme Court impose the 200% rent?
The Supreme Court imposed 200% rent back to the date that the Appellate Division had deemed the lease terminated, however, which was in 2014. The procedural history here is a little bit messy. During the course of the litigation.
It's on November 9th, 2017, that we reinstate the fact that the tenant belongs out of the premises, right?
In that decision, Your Honor, this court said there was a narrow issue on appeal, and that is whether the lease had been terminated. And this court said, we're reversing the trial court's finding that the lease had not been terminated.
Terminated as of January 12, 2014.
That's correct. There had been a partial settlement that narrowed the time period in issue from October 1st, 2016 to the date of eviction. And our point, if I can move on to the lease language itself, this lease, Article 59B, simply does not apply here. Article 59B says holdover rent will be available if the tenant remains in the premises following the expiration of this lease. Article 59B does not say that holdover rent is permissible if the tenant remains in possession of the premises following the expiration or earlier termination of the lease, the expiration or other termination of the lease, as you frequently see in these kinds of commercial leases. In fact, the word termination does not even appear in Article 59B. The fact is this lease never expired and its expiration date was never achieved, so Article 59B should never have come into play. The landlord's argument, obviously, is that when Article 59B says expiration, well, it really means termination. But that can't be, and there are several reasons why that can't be. Most compellingly, the parties knew how to use the word termination. They knew how to specify.
Doesn't Article 17 negate the argument you make about expiration? that expiration has some specific meaning as opposed to termination?
No, it doesn't, Judge, and there are a few reasons why not. First, if we look at, there are various other rider
Because
provisions.
that says a lease comes to an end after 3 days' notice. If you've got to get out, then it's treated as if the lease had expired at the end of its term.
It is treated as if the lease had expired, but that does not, there's no connective tissue between Article 17 and Article 59B. We're ascribing a lot of meaning and weight to Article 17, which is in the boilerplate printed form of the lease.
How about Article 21, upon expiration or other termination of the term of this lease? Again, expiration and termination being used interchangeably.
I don't think they're being used interchangeably there, and in fact, not only does Article 21 uses the word expiration and termination as separate terms, but I think more significantly, numerous rider provisions say expiration or termination. Glaze will have XYZ obligation after an expiration or termination. If expiration automatically meant termination, the parties in this rider would not have said termination. In fact, if we say, well, Article 17 negates that, we believe that's not a permissible construction of the lease because it makes the word termination in those numerous other rider provisions superfluous. And we cited case law that that's a cardinal rule of construction. You can't read a contract in a way that renders any term without meaning. And frankly, the parties knew how to use the word termination. They did it in several places in the customized riders to the lease. We think the word termination should be given meaning where it appears, and where it doesn't appear, it shouldn't be given meaning. The parties knew how to say termination, and they didn't do it in Article 59B. I'd like to also briefly say something about the attorney fee order. We're seeking reversal or at least a significant modification of the order granting attorney's fees. We set forth a number of arguments in our papers, but what I'd like to briefly touch on is the prior settlement. I see the lights on. If I could finish the thought, and then I'll...
You can finish the thought, and then you'll have time on rebuttal.
There was a prior settlement in this case before Judicial Hearing Officer Ira Gammerman in October 2016 that covered any amount due under the lease. Plainly, attorney's fees being sought under the lease under Article 19 incurred through that date, which, by the way, are also defined to constitute additional rent, should be barred and should not have been awarded in the trial court's decision awarding fees. Those fees were released as part of the October 2016 partial settlement.
Okay, thank you.
Good afternoon, Your Honors. May it please the Court, Kirk Zanitas for the respondent, MacArthur Properties, the landlord in this matter. In answer to your question, Your Honor, the holdover rent was assessed by the trial court from October of 2016 to the date of eviction, April of 2018, two and somewhat...
It started after the date of the settlement.
It started after the date of the settlement, correct, and it did not go as far back as when this court determined that the lease had terminated in January of 2014. The distinction or the attempt to distinguish expiration and termination, not only are they used interchangeably, but in keeping with my colleague's argument, Article 17 would be completely superfluous if we don't, if it's not applied. In fact, the lease here was terminated pursuant to Article 17. A notice of cancellation was served, and at the end of the period, the cure period, a 3-day notice of cancellation was served, therefore terminating the lease. So Article 17 was the provision that was used to terminate the lease, and that provision specifically says that it says termination and expiration is used interchangeably. It's as if the lease had expired by its term. So with regard to that issue. With regard to the attorney's fees, there are questions that are raised. The only issue that was raised below was to the threshold issue of whether attorney's fees, whether MacArthur was entitled to attorney's fees in the first place. There was no challenge to the invoices. There was no challenge to any of the factors that the court considered. All the factors under In re Freeman were considered and set forth, both in the affidavits. No challenge, no objection to any of that. The only challenge was to the issue of whether attorney's fees were warranted to begin with. Another issue raised in the appellant's brief is whether MacArthur was in fact a prevailing party. Clearly, there's no question that MacArthur here was the prevailing party. There's nothing in the lease or Article 19 of the lease that says that MacArthur would be entitled to attorney's fees even if it were not the prevailing party. Specifically doesn't state that. In fact, Article 19 states exactly the opposite. It says if the tenant is in default, then the landlord would be entitled to attorney's fees. That presupposes a prevailing party status. But besides that, clearly the record is clear that MacArthur was the prevailing party. Not only was the Yellowstone injunction vacated, the complaint was dismissed, the MacArthur prevailed on its counterclaims and prevailed on the eviction, and the scope of the claims were clearly met with regard to MacArthur's entitlement to those fees. Your Honors, if anyone has any questions, I'd be happy to answer them.
No, thank you.
Thank you, Your Honor.
Thank you for your argument. Okay, rebuttal.
I'd just like to briefly respond to something going back to Article 17 for a minute, the landlord's argument that expiration and termination are used interchangeably in this lease. The landlord still doesn't, and I don't think can account for the fact that there are numerous rider provisions that say expiration or termination. If expiration always meant termination, those provisions simply would have said expiration, period. Glaze shall have such and such
So what does Article 21 mean when it says upon the expiration or other termination of the term of this lease, the tenant shall quit and surrender?
We believe Article 17 and Article 21 should be read together. Basically, Article 17, the landlord's argument is, oh, well, the tenant is trying to read Article 17 out of this lease. First of all, the lease expressly contemplates that there could be rider provisions that take precedence over a contrary suggestion in the printed form of the lease. But if we go to Article 17 and Article 21, the purpose of Article 17 clearly is to make sure that things the tenant has to do at the natural end of the lease term, it will still do if the lease comes to an early end. For example, return the premises in broom clean condition, remove property, and most importantly, vacate the premises. Article 17 doesn't speak to any financial obligations that this tenant is going to have if the lease comes to an early end, and it certainly doesn't say that the tenant will have any holdover rent or 200% rent obligations. By the same token, Article 59B doesn't refer back to 17 or purport to be modifying 17. So we have Article 17 that really is a housekeeping.
Article 21, which upon expiration or other termination.
Again, I don't think that Article 21 stands for the proposition that these are interchangeable terms. The parties did not use them interchangeably in the rider.
I don't know that we have to go so far as to say they're interchangeable. It seems to me it's a serious hurdle for you to overcome in the argument that you're making here when you look at Article 21 in terms of expiration termination.
Article 21 is not the basis on which the trial court awarded holdover rent. The trial court awarded holdover rent on the single premise that Article 17 renders the word expiration equivalent to termination. And our argument is that that's not a permissible construction of the lease. Not only did the parties know how to use the word termination as demonstrated in numerous rider provisions and its absence in 59B, but if we read Article 17 and certainly 21 the way Your Honor is suggesting, that would read out and render superfluous the word termination in numerous other provisions of the customized rider.
Okay, thank you.
Thank you.
Thank you both. Denson versus Trump. You may proceed.
Good afternoon, Your Honors, and may it please the Court. I'm David Bowles of Bowles & Johnson, and I'm here to argue for Jessica Denson, the plaintiff appellant in this matter. Your Honors, 2 years ago, we were before this Court, and the Court vacated an arbitration award, and the Court did so on the grounds that the arbitrator improperly punished plaintiff for availing herself of a judicial forum. All we're asking the Court to do today is extend the logical reasoning behind that, and if the arbitrator punished punished Ms. Denson for availing herself of court, then certainly the campaign that asked the arbitrator to do so must have punished her as well.
Well, that was in a different context. That was in the context of public policy, and why we didn't think that the arbitrator should have denied your client the right to come to court. Here, we're talking about a different legal principle, and that is, after that decision, you amended your complaint, and you now have a retaliation claim under the employment discrimination laws that are based upon the filing of the arbitration claim, right?
Absolutely, Your Honor.
Right. So we didn't address that claim, and we could not have addressed it because, in fact, it really wasn't before us on the appeal. In fact, it wasn't even in the case, right?
That's right, Your Honor. Of course.
And in that decision, though, we actually, I think as the lower court said, we kind of eschewed sort of side arguments on that and said we don't have a factual basis to otherwise decide the motivation behind the defendant to figure out why the heck they did this. And that is the key, is it not, to a retaliation claim. So with all that background in mind, why wasn't the court correct to say, no, this is in summary judgment. You might be right, but we need to go to trial on it?
Your Honor, to remind the Court that the Court is absolutely right. The retaliation claim wasn't before the Court at that time, but on the other hand, that court decision was dispositive as to the arbitration claim. That got rid of the arbitration claim entirely.
Public policy grounds. I'm very aware of it. I was on the panel. I know,
Yes, Your Honor.
I know the case very well.
I remember.
Yeah.
But the Court didn't have to
Exceeded
go
its
into...
authority and public policy, 2 grounds.
Absolutely, Your Honor.
Right.
The Court didn't have to go into motive when it was clear on the face what was happening. The arbitrator punished Ms. Denson.
We didn't make a decision about motive at all, period.
Yes, Your Honor.
We weren't talking about motivations. We were talking about public policy. We didn't want to deny her a forum of going into court to make a complaint. That was really it. Right. There's a public policy consideration.
I understand, Your Honor, but now we have brief summary judgment to the lower court, and we think that that summary judgment motion should have been granted. As with many cases, there's one piece of evidence that I think is compelling in this. It's at page 122. It is, of course, the campaign's arbitration demand. The arbitration demand said exactly why they sued Ms. Denson. They sued her because she breached her obligations by publishing confidential information and disparaging statements in connection with a lawsuit she filed against the claimant in New York Supreme Court. In other words, they sued her in arbitration because she brought a sex discrimination claim. And that is absolutely an admission to retaliation. And they keep admitting it over and over again, Your Honors. It's an admission in the Glasner affidavit, in the Cannon affidavit, in the brief itself. My opponent says the campaign commenced the arbitration because it believed the plaintiff had published certain information and made certain statements in her state court complaint. That's page 19 to 20. Over and over again, they say why they sued Ms. Denson. They sued Ms. Denson because she brought a sex discrimination claim. You can't do that under the New York City human rights law. It is expressly retaliation to do so. And the court doesn't need to dive into motives when they're simply admitting it over and over, exactly why they did it. To make it worse, the Cannon affidavit, the campaign's in-house counsel stated that the campaign wanted it to be known that it fully intended to enforce the NDA. What he was saying there is they wanted to make an example out of Ms. Denson, not only to retaliate, but to retaliate in such a way that everybody else would know, all the other employees would know that they can't sue the campaign. Admission after admission of retaliation.
I'm sorry, counsel,
Yes, Your Honor.
was that testimony, you talked about the testimony by Mr. Cohen before the House?
We haven't even mentioned the testimony by Michael Cohen before the House, but he did testify, I believe under oath, to the House of Representatives, and he was asked specifically about Ms. Denson's non-disclosure agreement and its purpose. Was it to keep people quiet, to suppress their speech? And he said, yes, that was the purpose of it. But the documents we were talking about have all been submitted in the summary judgment pleading. The Glassner affidavit, the Cannon affidavit, and then I just quoted from my opponent's brief in this matter. There's only 4 elements to a claim of retaliation, and we think that there's no legitimate issue of fact on any of these things. Did Ms. Denson engage in a protected activity? She certainly did. Filing a civil action.
We understand. Really, it comes up to whether the excuse that they're giving is pretextual or not. Is there a factual issue on that that should go to trial as opposed to summary judgment?
We argue there is not. Their burden is to lay bare their proof, Your Honor, and that means bringing forth actual admissible evidence. All they have done is make a completely conclusory statement in the Glassner affidavit that they did this in good faith.
You made this motion before the EBT of Glassner was conducted, right?
Before the EBT of
Glassner.
We've never taken Mr. Glassner's deposition, Your Honor. This was in an affidavit that Mr. Glassner submitted.
Right, but there's been no EBT of Glassner.
That's right, Your Honor. There's not. There's not. I see my time is up. I'll reserve the rest for rebuttal. Thank you, Your Honors.
Okay, thank you.
Good afternoon, Your Honors. It was the plaintiff who moved for summary judgment before the lower court, not the campaign.
We are aware, but we know the rubric, and so you had to come up to show that the actions you took were not pretextual, right?
Correct.
All right. And how'd you do that?
Well, with Mr. Glassner's affidavit, we demonstrated legitimate non-retaliatory reasons for commencing the arbitration. It was the plaintiff's burden in response not to stand silent, but to come forward with evidence of pretext by showing that Mr. Glassner's explanation was somehow false, misleading, or incomplete.
Has plaintiff sought to take the deposition of Glassner?
Not yet. And we believe that that is crucial. The primary issue with respect to the plaintiff's retaliation claim comes down to the campaign's motivations for commencing the arbitration, whether those claims were asserted in good faith. You cannot possibly come to a resolution.
Come down to Glassner's motivations.
Exactly, and the campaigns in general. You need to have retaliatory animus to prove the claim. There's no evidence in this record at all to show retaliatory animus. Therefore, the motion is premature, and there needs to be discovery. There's a lot of outstanding discovery here, and even if there was discovery, it's necessarily going to come down to a fact issue that needs to be decided by the jury. I believe this court has held numerous times, in the Bennett case in particular, that even if there is some showing as to pretext, which we dispute has even happened here, a host of jury questions come into play. This is not a question of law for the court.
Counsel, in Glassner's affidavit, does he explain what language in the complaint is actionable?
He does not, Judge. And
does he have to?
I don't believe that he does.
Why not?
Because the burden in this respect, as the opponent of the motion, was to simply provide a reason, a legitimate non-retaliatory reason for its conduct. Mr. Glassner has done that.
Just by saying a blanket statement that something in the complaint was actionable without pointing out what it was?
Well, we don't believe that it's a blanket statement.
It's not specific, right? If it's specific, let me know what I missed.
Say that again, Judge?
If there's a specific allegation as to what is actionable, tell me, because I missed it.
Well, that's the missing discovery. That's exactly right. That's why the plaintiff had to take, or still has to take, Mr. Glassner's deposition. Put those questions in.
Mr. Glassner knows that. He knows what it is that motivated him, that he said, gee, we have a claim on this. So I don't know why he needs discovery to figure out why he made the decision he made.
Well, that's why I
What did
came
he-
back to who filed the motion. That's important here. It's not the campaign coming.
No, I understand the burdens of proof. I think you're not really answering either my question or my colleague's question. Mr. Glassner, he comes forward with affidavit and said, no, we had legitimate motives, but and you're saying we need discovery for him to further explain that? I don't get that. Why does he need to know more? He knows his motivations and what motivated him. Why is it just in this sort of general statement? And is that enough? Is that enough?
That is certainly enough in the context of opposing the plaintiff's motion for partial summary judgment pre-discovery before the plaintiff herself even testified in this matter. There is no affidavit even from the plaintiff or testimony challenging Mr. Glassner's.
Mr. Glassner does assert that he believed that it was important to enforce the contractual confidentiality and non-disparagement rights under the agreement.
Correct, and that is a legitimate non-retaliatory business reason. The court may disagree.
To enforce it, don't you have to have a breach of it?
Of course, and the campaign in good faith believed that there was a breach of it. The campaign prevailed.
I'm asking you specifically, what was that good faith belief? What did she breach? What was the language that breached the non-disclosure agreement?
And I understand what Your Honor is asking, but I'm saying that that is the information that the plaintiff needs to elicit from Mr. Glassner.
So you're saying there's a breach, but we can't tell you what it is until they tell us what it is.
No, that's not what I'm saying. I'm saying that there was a breach and that these claims were prosecuted before an arbitrator. The campaign.
It's easy to say that there's a breach when I'm asking you what was it.
The breach needs to be elicited from Mr. Glassner. Me as counsel can't testify on behalf of the campaign. There's no evidence in the record
I understand
here.
that, but he doesn't put that in his affidavit.
He does not put that in his affidavit. That's
Counsel,
correct.
Are you essentially saying that you don't know what the breach is?
I am not saying that at all. I am saying that it is the plaintiff's obligation, who has the burden of proof on proving this claim, to elicit that information from Mr. Glassner. It is not the campaign.
I think that seems sort of backwards in the context here, honestly, because he says, look, here's my proof that this is retaliatory. I have a legitimate right to go to court, and you brought it against me because you didn't want me to go to court. You wanted to increase my legal fees. And as far as I can tell, the demand for arbitration said you made statements in a state court action that violated. I mean, doesn't Mr. Glassner owe some kind of explanation how that gets tied up in good faith? Why couldn't she bring a court action?
Well, she 100% could have brought the court action, and the campaign.
So what did she say in the court action that violated the NDA, assuming, we'll assume for a moment that it was enforceable because you believed it at the time, even though now it's apparently not.
Correct.
You really think that Mr. Glassner didn't have to say more?
I 100% believe that the campaign met its burden in this context of coming forward.
Well, the law sort of changed because of the decision on the arbitration, but it does say, such as by filing her complaint under seal or by eliminating the confidential information from her complaint.
Mm-hmm.
That is in his affidavit.
It is, and you have to understand that the plaintiff asserted numerous.
Is that your complaint that she didn't file it under seal?
I'm sorry, Judge.
Is that your issue that she or Mr. What's his name? Glassner's issue that she didn't file it under seal?
That is one of the things that she could have done, but then again,
Did he say that in his affidavit that was one of the issues?
He did say that, yes.
Okay, and in terms of well, go ahead, Counsel.
I'm just saying that the primary and only issue before this court is the campaign's motivations, right? Whether there was a breach of the NDA or not, it's academic at this point because obviously the NDA.
How can anyone assess the motivation of the campaign when the campaign's saying there's an allegation of a breach, but we're not going to tell you what it is?
Not saying they're not going to tell you what it is. As soon as Mr. Glassner subpoenaed the testified at deposition, I'm sure he's going to elucidate all of us on the campaign's actual thought process in filing this arbitration to begin with.
Why couldn't that have been placed in the affidavit? He would be the person with that knowledge, right?
He is the person with that knowledge, and it could have gone in the affidavit, but with all due respect, the campaign's burden is not a demanding one in opposing the motion. The campaign was not seeking judgment as a matter of law. It was the plaintiff who was seeking this extraordinary relief pre-discovery prior to taking any depositions.
So this is a most curious position, I must say. I know that the confidentiality proviso says that all information that Mr. Trump insisted remain be private or confidential was barred from discussion, disclosure, and so on, right? So that's a very amorphous standard.
Yes.
And now you're saying that the breach is an unnamed, undisclosed breach. So are you saying, sorry, it hasn't been identified, it won't be identified until deposition?
Correct.
Is that because you're piggybacking on this language, that it's simply all information that is deemed private or confidential?
Not piggybacking on the language, the campaign completely acknowledges that that NDA has been declared unenforceable. Again, the only issue here is motivation.
So how do we know that the breach is an enforceable breach? If you don't identify the breach, how does anybody know, what is it? It's like a cloud, you know?
The breach is not an issue here. What is at issue here is the motivations of the campaign. The breach is rendered academic. There is no more breach. But it's whether at that point in time, when the demand for arbitration was filed, whether the campaign did so with unlawful retaliatory animus. And that is the evidence that is not existing in this record.
Ultimately, with that demand for arbitration, a judge ordered that arbitration to go forward,
Yes,
and you prevailed at that arbitration.
yes.
It was only at the decision at this court that that arbitration no longer became a permissible way to go.
That's correct. If the panel has nothing further.
We'll hear from your adversary in rebuttal.
Thank you, judges.
Thank you, Your Honors. And if there's one big point I've got to make, it's we've done discovery on this.
Can pursuing an arbitration
Yes, sir.
be unlawful retaliation when that arbitration proceeding was ordered to go forward by a federal judge, whether correctly or not, because ultimately is a different decision by a subsequent federal court, but it is ordered to go forward by a federal judge. And when you have the arbitration proceeding, you lose at that arbitration proceeding.
Yes, Your Honor.
So until that point, you could never, ever have possibly claimed that pursuing that arbitration was an unlawful discriminatory act.
I think we could, Your Honor.
You could, because this court said that that arbitration should never have taken place.
No, Your Honor. I think you can right from the date that she gets the arbitration demand. Again, they are suing her.
A court-sanctioned arbitration proceeding could constitute unlawful discrimination?
Yes, Your Honor, I think so. If that argument had been made at the time, then I think absolutely it could. Because they brought their arbitration demand specifically because Ms. Denson brought a New York City human rights claim, and that is absolutely sanctioned, protected behavior under the law. She didn't make that argument at the time, she was pro se, but I think that argument is compelling then and today, Your Honor. If I can make just one point on discovery, Your Honor. Mr. Blumetti makes it sound as though we haven't done any discovery. We've been asking for how Ms. Denson violated this NDA ever since this case started. We've asked for it in interrogatories, we've asked for it in depositions, we've asked for it in these pleadings where they were supposed to lay bare their proof. We deposed the campaign's person most knowledgeable, someone named Sean Dolman, and I asked him these questions personally. I said, point to a provision in Ms. Denson's complaint that was offensive to you, that was so offensive that you had to sue her for it. They have refused to do it, not only been unable to do it, but absolutely refused to do it. I've done demand letters, and they said they're simply not going to do it, and they have not done it today. The whole idea that we should have deposed Mr. Glassner, who frankly we had not heard of until this summary judgment briefing, is nonsense. We've been asking for this, they've refused to say. If the court has any more questions?
Nope, thank you.
Thank you, Your Honors.
Gentlemen.
Thank you.